We occasionally get emails from people who have what you might call an oral lease, a handshake lease. The tenant gives the landlord a check for a security deposit. And then prior to move-in day, the tenant changes their mind and says, by the way, I'm not going to rent here. Can I get my security deposit back? How does that normally shake out?
Not well. I mean, the shaking is confusing to begin with because nobody really knows what that money was in the first place. I think tenants seem to think that that was some sort of deposit. If they didn't end up renting the place, they get it back. The landlord thinks it's a true security deposit, which means that when the lease didn't occur, the first month's rent was not paid, and so the security deposit came into play. But it's a perfect example of why things should be in writing, even though it's legal not to have them in writing. That kind of confusion is what you're likely to see when you don't put things into writing.
And does it occasionally happen where a landlord-tenant meet and they say, yes, we agree, I'm going to rent your house, and the landlord says, okay, I'm going to prepare a written lease for you to sign, and at that moment in time, the tenant gives the landlord a deposit, but no written lease is ever signed before the tenant cancels the lease? Would that still be a lease?
Well, it's a lease, but I think a court would interpret that as a month-to-month tenancy. And so since the lease was never signed, there was never an agreement for what typically would be a year's lease. But apparently the parties reached some sort of agreement. And when we're into oral agreements in which something happened, courts interpret those as month-to-month tenancies.